A 6-3 Supreme Court emergency order just dropped, and it's about to transform how federal courts can restrict your Second Amendment rights across state lines. The justices made this call overnight, and legal experts are calling it the biggest shift in judicial authority we've seen in decades. This isn't some abstract legal theory. This decision determines whether a single judge can freeze gun laws in all 50 states, or if your firearm rights will depend on your zip code. Before I explain exactly what changed, click subscribe so you don't miss critical gun rights updates like this one. What the court actually decided. Let me walk you through what happened in this emergency filing. The Supreme Court released this 6-3 split decision that fundamentally alters how federal trial courts can operate when reviewing state firearms statutes and other laws. The majority ruled that district judges can no longer issue sweeping coast-to-coast injunctions blocking state legislation when only a small group of plaintiffs brought the lawsuit. This might seem like procedural minutia, but think about it this way. In the past decade, more than 60 nationwide injunctions came from individual federal judges, essentially giving one person in judicial robes the power to override entire state legislatures representing millions of citizens. What the High Court just did was stop that practice cold. The timing matters enormously because, right now, 47 pending federal cases involve states requesting precisely these kinds of universal injunctions. But there's one angle of this ruling that's flying under the radar, and it's going to spark the biggest battles ahead. The Originalist Foundation. You didn't expect. The constitutional logic supporting this ruling goes much deeper than initial legal commentary suggested. Justice Gorsuch's additional opinion traces historical precedent from 1789 to 1850, demonstrating that federal courts during America's founding period never issued an injunction extending past the actual litigants standing before them. He analyzes 12 distinct founding-era cases where judges explicitly refused requests for expanded relief, even when plaintiffs claimed efficiency justified broader orders. This historical deep dive carries weight because it reveals that nationwide injunctions lack any constitutional pedigree whatsoever, and only emerged because contemporary courts essentially created them without legal basis. Justice Thomas pushed even harder in his separate opinion, invoking Article 3 of the Constitution and contending that federal judicial authority is intrinsically confined to cases and controversies, which inherently means particular disputes between real parties, not theoretical policy battles affecting millions who never entered the courtroom. The dissenting justices attempted to rebut using civil rights precedents from the 1960s, but the majority essentially declared those rulings were incorrectly decided on this precise procedural question. What makes this truly combustible is the impact on 15 states that already filed briefs assuming the old framework would continue. Your rights might now depend on which county you're standing in when you assert them. The instant political shockwave. Within 3 hours after this ruling became public, state attorneys general from 12 jurisdictions filed emergency motions in their active federal litigation. Texas invoked the decision across 3 distinct lawsuits challenging federal immigration enforcement policies. Florida cited it in 2 matters involving election procedures and social media oversight. Arizona applied it to a border security conflict that's been stuck in the Ninth Circuit since spring. The velocity of these filings tells you everything about how consequential legal strategists consider this transformation. Even more revealing is the internal response at the Department of Justice, where sources indicate senior trial attorneys convened an emergency conference call at 7 this morning to reassess strategy in 23 ongoing matters. The White House counsel's team is reportedly instructing federal agencies to anticipate state statutes they believed were halted to suddenly take effect, potentially within days in certain jurisdictions. Republican governors are already declaring intentions to enforce legislation that's been frozen by injunctions, while Democratic state legal officers are racing to determine how to shield their constituents from what they perceive as dangerous policies in adjacent states. But here's what everyone should really be asking. If your constitutional protections vary based on which state you're physically in when you exercise them, do you truly possess constitutional guarantees at all, or merely geographic privileges? That answer dictates what happens with the enormous doctrinal transformation coming next. The litigation playbook gets rewritten. This ruling totally dismantles the established strategy for how legal conflicts unfold in federal court. For 20 years, advocacy organizations across the political divide have employed a method called forum shopping, deliberately filing suits in districts with judges known to grant nationwide injunctions. The statistics here are staggering. From 2017 through 2021, 78% of nationwide injunctions against federal actions came from judges in merely 5 particular districts, despite those districts representing under 4% of America's population. The most glaring example was the Northern District of California, where 3 judges issued 19 nationwide injunctions over 4 years, exceeding the entire Fifth Circuit's output during that identical period. Now that the Supreme Court has essentially eliminated this tactic, plaintiffs must file in numerous jurisdictions simultaneously if they want comprehensive impact, which means litigation expenses are about to skyrocket. A case that previously needed 1 filing in one favorable district might now demand 15 or 20 filings spanning different circuits, each requiring distinct counsel, separate arguments customized to regional precedent, and individual appeals upon defeat. Major law firms are already circulating internal memos to clients explaining that civil rights challenges, environmental disputes, and constitutional litigation could now cost 5 to 10 times what they did last month. But what virtually nobody has recognized yet is how this affects the one category of case where the consequences are literally life and death: the survival-level policy consequences. Let's examine what this means for concrete policy execution on the ground, starting with domains where the effect will hit fastest. Immigration enforcement is the obvious flashpoint, with ICE presently operating under 14 separate injunctions limiting different elements of removal policy, custody standards, and refugee procedures. Under the revised framework, numerous injunctions might only function in particular districts, meaning federal immigration agents could restart complete enforcement in states not covered by those orders, potentially once lower courts issue clarification rulings over the next 30 to 60 days. Second Amendment litigation is equally impacted, with firearm regulations in 6 states currently halted by nationwide preliminary injunctions preventing enforcement during appeals. If those injunctions get restricted to protect only named plaintiffs, state authorities could instantly begin enforcing gun restrictions on everybody else, generating a scenario where your Second Amendment protections effectively transform the instant you cross a state boundary. Healthcare access constitutes another critical friction point, especially concerning abortion pharmaceuticals, gender-affirming treatments, and religious exemptions from insurance requirements, with 11 active matters where nationwide injunctions currently stop state or federal enforcement. We might be operating as 50 separate legal systems under one constitution. Environmental regulations face similar entanglement, with the EPA confronting injunctions blocking clean air mandates, water safety protocols, and climate-connected rules in ways that could now be geographically limited rather than applying nationally. So here's what you must consider. If federal statutes can be enforced in Texas but not California, or the reverse, based purely on where plaintiffs filed lawsuits, are we still functioning as one nation with one constitution? Or have we effectively established 50 distinct legal frameworks? That question grows more pressing when you examine what's unfolding with election law at this moment. The election law powder keg. Election litigation is about to become extraordinarily complex, And the timing couldn't be more delicate considering we're entering a presidential election season. Presently, 9 nationwide injunctions affect various dimensions of voter identification statutes, mail ballot protocols, early voting mandates, and voter roll management across 19 states. Under the Supreme Court's fresh framework, those injunctions might only shield voters in the particular counties where plaintiffs reside, meaning identical state legislation could be enforced in 80% of a state while being blocked in the remaining 20% based solely on lawsuit geography. This generates an absolute catastrophe scenario for election officials who need to know months beforehand what regulations will govern their elections so they can train poll workers, produce ballots, and establish voting sites. The National Association of Secretaries of State released a statement this afternoon voicing serious worry about the operational pandemonium this could trigger if injunctions get geographically confined immediately before major elections. What amplifies the volatility is that both political parties have depended heavily on nationwide injunctions to contest election statutes they oppose, meaning both factions are losing a tool they've wielded extensively. Between 2018 and 2023, conservative organizations obtained 8 nationwide injunctions blocking various election procedures, while progressive groups secured 11 such injunctions during that same span. With that instrument now effectively eliminated, we're probably going to witness election regulations vary dramatically, not merely state by state, but potentially county by county inside the same state, depending on the patchwork of limited injunctions that stay in effect. The question is whether Congress will intervene to establish uniform federal guidelines, or whether we're about to experience the most legally turbulent election cycle in contemporary American history. The corporate and economic upheaval. Corporate America is discreetly alarmed about this ruling, and for valid reasons. Enterprises operating in multiple states suddenly face the possibility of navigating 50 different regulatory landscapes where federal mandates might be enforced in certain locations, but not others based on the geographic boundaries of various injunctions. The U.S. Chamber of Commerce calculates that compliance expenditures for multi-state businesses could rise by $47 billion annually if they must maintain different operational protocols in different jurisdictions based on which federal regulations are blocked by limited injunctions in which districts. Banking regulations face particular disruption, with 3 significant rules governing digital currency, lending criteria, and consumer safeguards currently frozen by nationwide injunctions that might soon only apply in specific circuits. Technology corporations confront similar ambiguity around content moderation obligations, data privacy mandates, and antitrust enforcement, where injunctions that currently deliver nationwide clarity might soon create a state-by-state mosaic of requirements. Healthcare providers and insurance carriers are examining potential disorder around coverage obligations, prescription medication pricing, and telehealth regulations that could fluctuate based on geography rather than being consistent nationwide. The pharmaceutical sector is especially anxious about FDA enforcement measures, with 5 current injunctions blocking different aspects of medication approval and surveillance requirements that might now only protect firms in particular jurisdictions while leaving others completely vulnerable to federal enforcement. Employment counsel are already advising their corporate clients to anticipate different workplace rules, compensation requirements, and anti-discrimination policies depending on where each location operates and whether that site falls inside the geographic reach of any limited injunctions. What's especially aggravating for businesses is the uncertainty element, since they won't know which injunctions survive under the fresh standard until lower courts reconsider each matter individually. The civil liberties dilemma. This is where philosophical principle collides with constitutional structure, and it's the debate that has legal academics most polarized. Civil rights organizations are voicing profound concern that restricting injunctive remedies could compel victims of discrimination to wage the identical battle in dozens of separate courtrooms before securing nationwide protection. The NAACP Legal Defense Fund noted that during the civil rights movement, nationwide injunctions proved essential in cases like Brown versus Board of Education's enforcement, enabling courts to ban segregation throughout entire states rather than exclusively in the particular school systems where plaintiffs filed litigation. If those cases had been adjudicated under the fresh framework the Supreme Court just imposed, desegregation might have required decades longer, as each separate school district demanded independent litigation. Contemporary civil rights cases face identical challenges. When a state enacts legislation that purportedly discriminates against a protected class, should remedies be restricted to the handful of plaintiffs courageous enough to step forward? Or should they safeguard everyone in that class throughout the jurisdiction? The Supreme Court's majority opinion doesn't genuinely address this contradiction, instead concentrating purely on the Article 3 constraints on judicial authority, irrespective of the sympathetic character of the claims. Disability rights advocates are particularly concerned, observing that the Americans with Disabilities Act has been enforced primarily through expansive injunctions requiring systematic modifications to government services, public facilities, and employment practices. And it's ambiguous how effective enforcement would operate under a system of plaintiff-specific remedies. Here's the core tension. If preventing harm to vulnerable populations demands broad injunctive relief, but the Constitution restricts courts to resolving particular disputes between particular parties, which principle should yield, and who gets to make that determination? That question leads straight into what might be the most consequential dimension of this ruling that virtually nobody is addressing yet. The High Court Authority Assertion. What's genuinely occurring here is the Supreme Court reclaiming its own jurisdiction over the complete federal judiciary, and the ramifications of that authority reach far past injunctions. By releasing this ruling through the emergency docket, instead of awaiting a complete case with oral presentations, the court transmitted an unmistakable signal that it demands lower courts to conform immediately, not after years of additional litigation. This represents the culmination of a trajectory where the current Supreme Court has grown increasingly prepared to utilize its shadow docket, emergency directives, and summary reversals to regulate how lower courts function. Statistical examination reveals that the court has released 47 emergency directives in the past 3 years that altered or eliminated lower court rulings compared to merely 19 such directives in the preceding 3-year span. What makes this especially significant is that emergency directives typically don't contain complete reasoning or extensive legal examination, meaning lower courts are anticipated to conform with broad principles without detailed instruction on how to implement them in particular factual circumstances. Several appellate judges have privately communicated frustration with this methodology, suggesting it generates more ambiguity rather than less, because they're compelled to speculate at what the Supreme Court desires rather than having clear precedential direction. The practical consequence is that the Supreme Court is micromanaging federal litigation in ways that were inconceivable 20 years ago, intervening on emergency grounds to overturn district judges, circuit courts, and even state Supreme Courts, when the current majority believes those courts have surpassed their jurisdiction. This ruling on nationwide injunctions fits flawlessly into that trajectory. It's the Supreme Court informing hundreds of federal judges throughout the nation that they've been performing their responsibilities incorrectly for 2 decades, and they must modify their methodology immediately. Whether that represents appropriate appellate supervision or judicial excess depends completely on your viewpoint about how the federal court structure should operate. But regardless, it's a remarkable assertion of authority that's reshaping the complete judiciary from the top downward. Final thoughts. This Supreme Court ruling transforms everything about how federal authority functions in America, and we're merely witnessing the start of the consequences. If you want to stay current on significant legal developments like this, make certain you're subscribed to Firearm Legal Briefing, hit the like button, and leave a comment with your perspective on this decision.